Hey, good morning, everyone. Welcome to Law and Legitimacy. Yep, it's Friday. We made it to the end of the week, and we've almost made it back onto Rumble. Mike's done some investigative work and concluded and reached the conclusion that Rumble has a time delay in how it hooks up to us. So people on Rumble don't get notification until we've been on the air for about 3 minutes. So if you're a regular Rumble listener and there's a big boom and people around you start to irradiate and disintegrate, and you wonder what's happened, you might learn 3 minutes later that a nuclear bomb went off a couple blocks over, but you'd know what you saw with your own eyes, but you wouldn't have anybody there to interpret it. So we've agreed that we're going to tread water for a few minutes until Rumble catches up with us. We're trying to build followers to the stream for the most venal reason of all. We want influence, and that's why we do this every day. And so, Mike's been bitching and moaning about our Rumble numbers not being what they should be, sometimes very high, sometimes not. We're going to try to wait and see if the Rumble crowd can catch up with us. And if they can't, we'll move on. So while we're waiting, I want to remind everybody that it's Drop Dead Day. If you want to do ball and legitimacy and play fantasy football, I think today is the day you got to notify us. Mike mentioned yesterday that we had enough people with interest to fill a league, but we could expand the league if necessary. I'm 99% sure that I'm going to play, but it occurred to me last night that I don't really know much about sports. I don't really follow football. I'm an episodic fan, and that this is going to require my mastering draft lists and databases and whatnot. And how am I going to find the time to do that in the midst of everything else? So I probably will play, but if there are enough interested parties, I may not. So let Mike know. Mike, where are we on that?
First and foremost, you are absolutely playing. You're not getting out of this.
You're trying to draft me, are you?
Oh, no, I'm not trying. It's a requirement. It doesn't matter. It doesn't matter.
Fired if we don't.
It doesn't matter if you go 0-13 and don't.
It matters to me.
You're in. Okay.
All right.
You're in. As part of the appeal. Yeah. So we're good. It sounds. I think people are kind of slowly streaming in here. Happy Friday. We've got Jackson Barrett, BTL lawyer Will in the cloud. So people are slowly streaming in here. We can go ahead and get started, Norm, if you want. And then over on YouTube, we've got the pack of dogs. We've got Matthew, Kyle, Mari, Luttrell. Good morning to you, gentlemen.
So I got a call yesterday in the office. Would I consider representing Robert L. Peters? And and I'm interested, because I'm a lawyer. And tell me about your case. Well, it's national security. You'd have to have a security clearance. I said, well, then how do I know if I want the case? And they said, let's just say Robert L. Peters is a pseudonym for President Biden. And I'm like, oh, come on. What? He's got a secret name and it's going to be Robert L. Peters. I mean, why not Brandon? I saw some Twitter comments yesterday. Brandon B. Biden. That would look good. Brandon is, or Brandon B. Biden. We can play the hooked on phonics game and go about, conjoining verbs any way we like. In this, the most pluralistic and diverse of all societies ever to exist under the globe. Robert L. Peters. So the backstory is as follows. There's a Congressional Oversight Committee looking around at Hunter, trying to figure out why this crack-addicted, sometime father ne'er-do-well son of a president makes so much money and has problems with federal authorities over the non-payment of taxes and so forth, and the National Archives. And so the Oversight Committee is pouring through this. They're going through material published by the National Archives, including correspondence of the former Vice President, Joseph Biden, when they come across an indication that there's been communication that's been withheld from the public under under an exception to the Public Records Disclosure Act. And they realize, and Comer, the head, on behalf of the committee, writes a letter to the National Archives saying, we know that Robert L. Peters is in fact Joseph Biden, and that while he's sitting in the vice president's office, he's communicating by email with his son using a pseudonym, a fake name. And what are they talking about? Burisma and Ukraine. Now, you've kept from us, Comer says to the records keeper, documents that would explain what this is all about. We want them, and I'm with them all together on this. It's inconceivable to me that the Vice President of the United States of America is discussing with his son business relationships with a foreign entity that his son is involved in while Biden is Vice President of the United States, and Biden, in order to cover his tracks, uses a pseudonym. I mean, seriously, Mike, am I reading this right? Is this what this is all
you
about?
absolutely are. Well, and let's not forget that when pressed on this stuff, the current administration, we've got President Biden, who at the beginning was like, I've never talked to my son at all about business, right? Very,
But my alter ego has.
right. And then it's, I never had any influence over my son's business dealings. And then it's like just the shore just continually erodes on this story from his perspective. And of course, anything that you read that is supposedly favorable to the Biden administration is just really kind of running cover, saying that there aren't any emails directly, da 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 da. And then here we got the new pseudonym just dropped, right? Bobby Pete, right? We've got Robert Peters. So yeah, I think that James Comer is correct here. I think it's absolutely incredible that if the National Archives and the establishment had information and could have known about this pseudonym prior to now, with the House Oversight and Accountability Committee running this NARA investigation, it's interesting that it wasn't disclosed as part of general requests for information prior to now. And I think that is, I guess this is just sort of, Biden is going to be protected until he's no longer valuable, from my perspective.
I guess. I mean, to me, it's just it's jaw dropping, and I'll be curious to see what comes of this investigation. I mean, I assume Comer's right. He didn't say we have reason to believe. He said they know it. So let's see what happens. Let's see how the White House responds, if it responds at all. So
for PTSD, and Rumble makes a very interesting callback. He says, I recall Loretta Lynch used a pseudonym to avoid FOIA requests, which again, so this is really just interesting stuff here. And the question from Jackson Barrett, didn't elected officials used to be required to avoid the appearance of conflicts of interest? Well, of course, right? But that would be
well, that's the standard for judicial officials. I mean, I don't know that there is a standard for elected officials. I often believe we get the government we deserve, and I wonder which original sin this nation committed to be caught between the horns of the dilemma we now face with the two primary candidates. But we'll talk more, perhaps maybe Trump in a minute. Hey, big news
before we move on, just for our audio only listeners, I do want to read some of this letter so that because for the viewers of the stream, if you're unable to read the smaller text on the screen, but part and parcel to this letter, here's the second paragraph. Quote, the committee seeks unrestricted special access under the PRA to case number 2023-022F entitled Email Messages to and or from Vice President Biden and Hunter Biden related to Burisma and Ukraine, which has been published on NARA's website. These records have been redacted for public release pursuant to the PRA and FOIA. For example, an email bearing the subject, quote, Friday schedule card is withheld in part under a P6 and B6 restrictions, denoting personal information regarding the subject under PRA and FOIA, respectively. Attached to this email and made available on the NARA website is a document that indicates at 9 a.m. on May 27th, 2016, Vice President Biden took a call with the president of Ukraine, Petro Poroshenko. It is concerning to the committee, however, that this document was sent to, quote, Robert L. Peters, a pseudonym the committee has identified as then Vice President Biden. Additionally, the committee questions why then Vice President Biden's son, Hunter Biden, and only Hunter Biden, was copied on this email to then Vice President Biden.
Interesting questions. I mean, it would seem to me that if you're given an FOI request and the request is provide any and all documents that you sent to Joe Blow, you can't say my alter ego did it. I didn't do it. My alter ego, Mike Boyer did it. And Mike's an actual person. I mean, call myself Fanny Boyer. If I'm sending emails as Fanny Boyer rather than Norm Pattis, I'm still sending them. And so it seems to me that there are fundamental candor problems here. And we really need, I think we need to get to the bottom of this, because there are enough questions in my mind about what the Biden family was up to with the Ukraine, such that I no longer react with a scorn when I hear somebody refer to the Biden crime family. It's beginning to look a little dirty over there,
Yeah, just a tiny bit. Just a tiny bit. Well, look, we haven't talked about J6, and in particular, your representation of defendant Joseph Biggs, one of the 5 Proud Boys who was charged, and one of 4 that was convicted of seditious conspiracy in connection with the events of January 6, 2021. What have we got, Norm?
Well, we got a lot, and I now represent 2 of the guys in the Proud Boys, not just Joe Biggs, but Zach Rell. But yesterday, the parties' initial sentencing memoranda were due and were filed in court. So late last night, we filed ours. I believe one was filed on behalf of Ethan Nordine. I believe one was filed on behalf of Dominic Pizzola. I don't recall if I saw one on behalf of Enrique Terrio. The government filed it, and it was as expected. The government is so far over the top; they're in orbit. The government is requesting the following sentences in the Proud Boys case: 33 years for Enrique Terrio, 33 years for Joseph Biggs, 30 years, I think it is, for Mr. Rell. 27 years for Mr. Nordine, and I believe 29 or 30 years for Mr. Pizzola. And you're thinking, where do those numbers come from? They want these men designated as terrorists because under the sentencing guidelines, an argument can be made, and the government attempts to make it, that they used violence to intimidate or threaten members of government. When that protest turned into a riot and turned ugly by degrees at various points, the contention is these men were the functional equivalent of terrorists, domestic terrorists. And under these sentencing guidelines, when that happens, a massive recalculation of the offense conduct takes place, and they become eligible for a mandatory sentence of 360 months or 30 years to life imprisonment. And so the government is asking the trial court to impose a terrorism enhancement on these men, because when they when Pizzola broke a window, or when a fence was broken, this was as to counts, I believe, 6 and 7 of the indictment, or perhaps 7 and 8, I can't recall off the top of my head. This was done with the intent to intimidate members of the government. And this you've heard the expression that you can do anything with statistics. Well, you can also do anything with the sentencing guidelines, depending on how much integrity you want to have in your use of the English language and your interpretation of terms. Let me give you another example of some of the conflicts to come in the sentencing guidelines, over the sentencing guidelines in the Proud Boys case. But first, by way of review, for those of you who aren't lawyers or don't listen, and I don't know why you wouldn't, to this show every day and don't remember everything we've said. I don't know why you would either, since we can't even remember it all. But here's what the sentencing guidelines are. Under federal law, there are guidelines that are created by something called the United States Sentencing Commission. And these guidelines used to be mandatory. They were created, I believe, in 1984. And the purpose of creating them was to provide some uniformity in sentences across the country. The feeling was that when judges had discretion to sentence within the statutory range, 0 to 30 years. Some judges would give 1, some judges would give 20, and this didn't promote respect for the law because the numbers were so crazy. So the guidelines were designed to provide a cookbook, as it were, to reduce the factors that a judge should consider in sentencing to a point-driven system, such that a pre-sentence report would be written and the parties could argue over what points should apply to a sentence or what factors were important to a sentence, and then a given number of points would be applicable. So, for example, in the Proud Boys case, the seditious conspiracy and other charges carries a base offense level of 14. And then you can enhance those points based on specific offense characteristics. In the probation officer's view and in the government's view initially, well, let's back off. In the initial pre-sentence report drafted by a probation officer and circulated to the parties, that office concluded that 13 extra points should be assessed because these offenses regarded the administration of justice. We objected to that, saying no, this wasn't an offense pertaining to the administration of justice. Administration of justice typically means a courtroom proceeding, an indictment, or lawful process involving adjudication of an issue before a tribunal. This was an effect or impact on an official proceeding, to wit, a joint session of Congress counting electoral votes. Now, those of you who are non-lawyers are saying, well, is there really a difference? Well, some courts have concluded there is. If the sentencing guidelines wanted 13 points to be added to obstructing an official proceeding, they would have said so. Instead, they distinguished that an official proceeding from the administration of justice. So courts have differed on whether administration of justice and obstruction official proceedings are synonyms. We've preserved the issue. In this case, the government, and so on, the initial view of the Office of Probation was that these men should be sentenced to somewhere between 10 and 12 or 11 years or 13 years, depending on the defendant. The government has upped the ante fundamentally. And by claiming this terrorism enhancement, it is seeking the maximum possible number of points under law, and it also seeks to shift the men's criminal history. None of these men have, with the exception of Tario, have a criminal history that affected their sentencing. In other words, there are 6 columns in the table that give you an appropriate sentence. Mr. Biggs, for example, was a criminal history 0. He had 0 points for that, which put him in column 1, the least culpable sentence. The terrorism enhancement moves him all the way over to 6. And so he's treated as though he's a career offender with a long criminal record. The court is not obligated to sentence according to the guidelines, and there will be argument in Washington, I believe, on August 29th about whether the terrorist enhancement applies. The terrorism enhancement applies. We have briefs due next week challenging that. Keep an eye on the pleadings. It'll be an interesting discussion. But what's interesting to me is that in the Proud Boys case, the government is asking for far more time than they asked for in the Oath Keepers case. In the Oath Keepers, I believe they were looking for 25 years as to Stuart Rhodes, in part because of the terrorism enhancement. It was less than the 30 that they were entitled to, and I don't recall the reasons why it was less. Judge Maida sentenced Rhodes to 18 years, or roughly 70% of what the government sought. In this case, the government appears to be gambling high with the hope that if the court applies a common sense discount, it'll nonetheless give a catastrophic sentence. What am I talking about? Suppose you want to buy an item in the store, you think it's worth $10, but they've got it listed as worth 20, and they say on sale 13. You're thinking you got a $7 break because of the sale, but you're still paying $3 more than you should have. My view is that the psychology behind the government sentencing memoranda in this case is to ask for the world and then act content when they only get a continent. They're not even entitled to a state, in our view. In the sentencing memoranda we filed, we objected to the 13-point enhancement relating to administration of justice, an offense involving the administration of justice. We didn't yet respond to the terrorism enhancement because we hadn't seen it or the reasoning supporting it. But we took the view that an appropriate sentence in the Biggs and Rel case would be in the 3 to 4 year range. So clearly the parties are far apart. If history is any guide, the court will impose significant sentences in these cases. We will ask that they be non-guidelines cases. But I think it is very significant to note that the government is seeking more significant punishment as to the Proud Boys than they did as to the Oath Keepers. And it was the Oath Keepers who trained in a paramilitary fashion, who organized in anticipation of January 6th, who had guns across the Potomac in Virginia and were prepared to transport those guns via boat to Washington, D.C. if anyone but made a phone call to do so. Whereas the Proud Boys simply attended a rally. The government's contention is they organized a protest that was intended to be violent. We disagree with that. We will obviously talk at great length about these issues at sentencing. But right now, my heart goes out to the Proud Boys and their supporters. Last night,
Yeah.
I received a number of emails from families who are close to them that were that just devastating. I mean, the consider the fact that their loved ones might effectively spend the rest of their productive life behind bars as a result of a couple hours on January 6th. It seems like a mockery of justice to me.
Well, and Don McNeil asks a question here. I'll put it on the screen from YouTube. What was the sentence for the people who attacked the White House, injuring Secret Service and causing Trump to go to a bunker for which he was mocked?
I actually don't know, and that's a great question.
Because I remember that's the iconic image, a photo of Trump holding a Bible in front of the church. I forget the name of the church right now. But that was when he made the decision, and his Secret Service was advising him that he shouldn't, but he said no. We're walking, and there's that iconic image of him, images of him walking across the street from the White House to the church and holding up the Bible. I just, I'll always remember that. But when Don brought that up, I couldn't hang on to that. That's sort of, I guess, burnished into my memory.
Well, it's a great point. I mean, and that strikes me as the functional equivalent of this. And I suspect the sentences were relatively low, in the couple year ranges. And probably I'll make a note to try to look into that and report back on that later.
Don knew the answer to her own question. There were no charges in the White House.
Wow. Well, were there no charges because they were unable to identify any defendants?
I'm not sure. We can actually, maybe this is something that we should do some diligence on. I am interested in the comparison. So Don, if you have any information, send us an email. But we can kind of do a deep dive on this. I wanted to ask you before we move on here. I brought up the webpage from the Southern Poverty Law Center where they've designated the Proud Boys as a hate group. And here they have what I always find with respect to the Proud Boys, a really interesting aspect of their existence is that they were founded first and foremost by a literal comedian.
Gavin McInnes. Yeah.
He one hilarious guy, very funny, very creative, and extremely bright. It was if you listen to him talk about it, it was quite literally a joke, right? And if you follow the chronology from their origins, throughout I guess the first 4 years there to November of 2020 and then January 6, 2021, it baffles me, Norm, that we have something, like the Southern Poverty Law Center designating on their website an organization such as the Proud Boys as a hate group. And then the Justice Department more aggressively trying to sentence the members of the Proud Boys than, like you said, the Oath Keepers, which are, in my mind, when I always thought when we were going through this, Norm, I was like, well, at least the Proud Boys aren't the Oath Keepers. So it's kind of this refrain in my head. I don't know. And I never said that out loud, but it seemed like a nice mitigating factor. Well, it's not as bad as it could be, but apparently it is.
Well, I mean, who's the real hate group here? The Proud Boys say that they're proud of Western civilization and refuse to apologize for the creation of the modern world. There was a point in our history where universities taught courses in Western civilization, and people were led to believe there was something distinctive about the values that created the world in which we live. Those ideas are under attack now, and in my view, the Southern Poverty Law Center is really the hate group here. They get to decide who is not appropriate to listen to, and they've designated largely a drinking club that was thrust into national prominence when Donald Trump called them out in a presidential debate, and their membership rolls swelled, and then they got caught up in the crazy moment of the end of 2020 and early 21, and participated in a riot that was in part at times violent. But their role in organizing it, directing it, and participating in it has been vastly overstated. And the government sentencing memorandum in this case just causes me real distress. I like the prosecutors that I met in this case. We worked hard together in this case. I think they're people filled with integrity, but I couldn't disagree more with what they're doing in this case, and what they're doing and their manner in doing it makes me feel as though we're living in different countries and applying different standards to common events. And that is the very definition of a legitimacy crisis. Hey, let's flip real quick to while we're talking about crises, an odd decision in the Fourth Circuit Court of Appeals, the Federal Court of Appeals, basically saying that parents don't have standing to complain when schools work with their children who are attending school to engage in what I will refer to as gender propaganda. So Johnny goes to school and decides he'd like to be Jane, but he knows his parents don't like it. So the school will help him be Jane at school, but they'll deceive the parents about what's going on, using the quote unquote assigned at birth gender when communicating with the parents, but referring to Johnny or Jane, aka Johnny, as she in school. Some parents got wind of this and they sued, claiming that they have a fundamental right to raise their child, that at most the school district is serving in loco parentis, that is, in lieu of parents for the children when the children are in the control of schools during the day. But in the end, the right to control a child's education and educational environment belongs to them. And so they felt that their rights to familial association, this fundamental right to raise your child as you see fit, was being impinged upon by a school district that was permitted to engage in deceit as to these parents and to lie to them and to influence the very significant decisions as to a child's gender identity without even notifying the parents or cooperating with the parents or getting their informed consent. The Fourth Circuit upheld a decision to dismiss the lawsuit in a 2-1 decision, saying the parents didn't have standing to raise the claim. Standing, as you've heard us say here before, is the right to be heard. You may think that whatever you think of Mike and I, you might go to a court in your state and say, those guys are jerks, and the court might say, you don't have standing. Not only did you not raise a claim, because we're not, obviously, but standing bars the courtroom doors and says of a party or litigant, you do not have a claim that the court can hear. To my mind, I can't think of a more stunning court decision with respect to school children.
I'm actually going to share some of the part of the order here because I think it is stunning. It'll take me 2 seconds to read this, Norm, if you don't mind. This is from for those in the in YouTube chat. I know photography was asking. This is out of Montgomery County, Maryland. This is the Fourth Circuit Court of Appeals, and the Fourth Circuit is broadly this sort of like, if you're an ACC fan, an Athletic Coast Conference fan, you can bet that you're likely in or close to the Fourth Circuit. North Carolina is part of the Fourth Circuit, Virginia, Maryland, and you don't quiz me on the rest of those. But anyway, this emanates out of Maryland. And as Norm said, the issue of standing is where this court ruled 2-1 that the parents of the children in the school district subject to the policy didn't have standing. And the way they got there, Norm, I think is, frankly, it's incredible. So I'll just read a couple of paragraphs here from the opening, because I think that this illustrates it perfectly, sort of how ridiculous and narrow of a reading of standing this is from the majority. So Circuit Judge Quattlebaum says, Frederick Douglass famously said that our freedoms as Americans rest in the ballot box and the jury box. So true. But when may we open each appeal illustrates that dilemma. I have no idea what that means, Norm.
No, me neither. What's his name?
Quattlebaum, Circuit Judge Quattlebaum.
Boy, I'll tell you, if ever there were a judge that was aptly named, hi, my Quattlebaum's hurting. May I have some preparation H?
I don't even know. So true. Anyway, the Montgomery County Board of Education adopted guidelines for gender identity for 2020-2021 that permit schools to develop gender support plans for students. The guidelines allow implementation of these plans without the knowledge or consent of the students' parents. They even authorize the schools to withhold information about the plans from parents if the school deems the parents to be unsupportive. In response, 3 parents with children attending Montgomery County Public Schools challenged the portion of the guidelines that permit school officials to develop gender support plans and then withhold information about a child's gender support plan from their parents. Terming it the parental preclusion policy, the parents alleged that the policy unconstitutionally usurps the parents' fundamental right to raise their children under the 14th Amendment, which, as a sidebar, I think any reasonable person would agree with, right? But before considering the merits of the parents' argument, we must decide whether the parents have alleged that the parental preclusion policy caused an injury to them sufficient to give them access to the jury box, or stated differently, to create what we call standing. And And this case begins and ends with standing. And hold your horses there for a second, Norm. This is where it gets great. The parents have not alleged that their children have gender support plans, are transgender, or are even struggling with issues of gender identity. As a result, they have not alleged facts that the Montgomery County Public Schools have any information about their children that is currently being withheld, or that there is a substantial risk information will be withheld in the future. Thus, under the Constitution, they have not alleged the type of injury required to show standing. Absent an injury that creates standing, federal courts lack the power to address the parents' objections to the guidelines. That does not mean their objections are invalid. In fact, they may be quite persuasive. But by failing to allege any injury to themselves, the parents' opposition to the parental preclusion policy reflects a policy disagreement. And policy disagreements should be addressed to elected policymakers at the ballot box, not to unelected judges in the courthouse. So we remand to the district court to dismiss the case for lack of standing. I am absolutely blown away by how vapid and stupid of a couple of paragraphs that is.
Well, let me come to the defense.
An alleged constitutional violation is in and of itself the harm.
Let me come to the defense of vapidity and stupidity, which is often my appointed role on this show, as those of you who listen regularly know. So I think what he's saying is that a requirement of standing is something called injury in fact. You have to have an injury that the court is capable of redressing. Thus, that's justiciability. There has to be something for it to decide. And so insofar as you seek money damages, and I don't know if the parents did in this case, if there's no injury, there's nothing to decide. And if this is a mere hypothetical question that may or may not affect you, then it really is a policy decision. And that's a decision that should be subjected to review by elected officials and not the courts. I don't know enough about the pleadings in this case. It seems to me that they should have argued for declaratory or injunctive relief, and that they should have argued that, we don't know, in fact, if our kids are involved in a program like that at school, because the school wouldn't tell us if they were. And so the school doesn't get the benefit of playing hide the ball and say, because we've hidden the ball, you can't kick us. So it seems to me that this decision is vulnerable. I understand what the judge is trying to say. I'm just not sure on these facts that he should be permitted to say that without review. Now, it was a 2-1 decision. And under the federal rules of appellate procedure, when a panel of a larger group of judges makes a decision. So I don't know how many judges sit in the Fourth Circuit, but there could be as many as a dozen or 15. So, and usually a 3-judge panel decides a case. You've got a 2-1 vote here on a close call. The parties can ask for what's called a motion for rehearing and a motion for hearing en banc. That is, they can ask for the entire panel of the Fourth Circuit to hear this decision. And I suspect they will. They've got 14 days, typically, unless the local rules in the Fourth Circuit say otherwise, to file a motion for a rehearing. They're not required to do so, but I suspect they will. Once the Fourth Circuit renders a final decision, and this decision now is final unless there's a motion to rehear and the full panel decides to rehear it. Once that's done, you've got 90 days to file a petition for certiorari to the United States Supreme Court. So this strikes me as a narrow question, Mike. I think Quattlebaum's reasoning is suspect. I understand what he's trying to say, and I understand what the parents are attempting to do. And it seems to me that if we're going to live in a regime where we talk about substantive due process and the rights of individuals to declare their own conception of meaning, and we also recognize the fundamental right of parents to rear their children, and we recognize these as incident to so-called substantive due process, that this is a classic substantive due process case and that should go to the United States Supreme Court for review. My impression, though, Mike, is that if it goes up, they won't get 4 judges to hear it, because what will happen is the court will avoid this issue, saying that it was improperly pled and that the injury in fact component will frighten the court off. And so the parents
did the abortion issue not have this same issue of standing that American jurisprudence had to wade through early on?
Well, in the Roe v. Wade case, it did and it didn't. And so, as we all know, I hope, it takes 9 months for a human to be conceived and then to tumble out of the womb in some recognizable form. And so when Roe, I think it was Miss McCovey, who was the pseudonymous plaintiff there, brought her case, the initial problem was, hey, by the time the case gets heard by the Supreme Court, she will have delivered, so that she won't have standing. So there is an exception.
Moot, right?
Yeah, the case would be moot. There is an exception, and that is an event that is likely to recur and is capable of repetition, and thus would evade review. And so the abortion decision, the decision to hear the abortion case was the classic example of that. No woman conceiving or challenging a prohibition on abortion is going to be able to get her case heard within 9 months. And we know that women get pregnant, and therefore this is an important issue that raises serious issues and is likely to recur. And because of the unique characteristic of pregnancy, it's incapable of being reviewed. I'm not sure how I would decide this issue. I think if I were on the Supreme Court, I'd wait for a better plaintiff to come along. And my view is that the plaintiffs in this case need to sit with their lawyers and ask, did we plead this the right way? Do we have to have a child?
They consider this part. So I want to recognize the Legal Insurrection blog and Jane Coleman in particular. Jane Coleman did an incredible job on this article.
Is she related to Ron Coleman?
I believe Ron Coleman has the distinct honor of being married to Jane Coleman. So,
oh man, can you believe? I would be afraid if my wife were a legal blogger. I mean, I was talking to a real idiot the other day about the law, and my husband said,
right. Well, I guess it seems like this rhymes with that a little bit, Norm. And if we're taking what I was going to say is that this whole scheme was considered to be part of the curriculum of the school, which I think is insane, right? And because it was part of the curriculum, this wasn't something that was subject to scrutiny by parents to begin with, right? So we can dig in deeper into this. But what I was thinking is that this is interesting that the judge, Quattlebaum, would say that because they haven't pled injury in fact, and injury in fact in this case, really interesting that they would say, my child is transgender, therefore that is injury in fact. What the hell does that mean? What I'm saying is that the thinking behind all of this is that gender itself is fluid.
Right.
So from my perspective, the attorneys here should have been able to get ahead of this issue and said, it doesn't matter. And perhaps this is the basis for the appeal of the denial of standing, is that how are we to know if we
well, yeah, so that strikes me that there might be
susceptible to meeting it.
No, there might be a futility exception, to the standing requirement here with respect to the policy. We will never know because they won't tell us until irreparable harm is done to our child. I mean, how do
they even know? The only person that knows, according to their logic, is the child. So we could be injured in fact. It's more likely than not that we are, based on their logic. Let's take their logic as par for this, not ours.
If I'm the plaintiffs in this case, I don't give up. I take this ruling. I do a motion for rehearing and en banc. Maybe I consider a certiorari petition, but I also go back to the drawing board and file another suit. Because, it seems to me that relying on injury in fact is a way to avoid letting this case go forward on the grounds of standing, ignores the important public policy issues that the parents have every right and expectation to have heard. And if they need to tweak the pleadings in order to do so, then tweak it by all means, and move on.
I agree. Well, I think this is a case that should not end here, but our coverage for today will.
Yeah, well, I guess so. All right, well, folks, look, last call for ball and legitimacy. If you want to play fantasy football and match wits with Mike Boyer, this this is the time you got to write us an email and let us know. I think we've got a full subscribe. We've got enough people to have a small league. We'll take a few more and have a larger league. And, maybe I'll participate. Maybe I won't. Mike tells me I'm ordered to do so.
He's participating. Don't let him fool you.
I'm participating. So, we look forward to...
Send an email to pattispodcast@gmail.com. And I know we've got some kind of like, oh, what could be a bigger waste of time than fantasy football? I'm not saying I disagree. I'm not saying I'm not a degenerate. Okay.
Hey, and look at it. Here's a philosophical perspective on time wasting. Time wastes us all. I mean, live long enough and you'll find out. Why not? Isn't the most exquisite revenge wasting some of it? Doing Absolutely. What you want to do because it's fun. And so I say I love football. Any attempt to regulate it, make it more safe, make it more palatable to those who worry about everything. I'm not going down with that. I enjoy football, and we're going to have fun. We're going to talk smack. I'm going to go 1-12 is my prediction and be eaten up by the likes of Mike. But I will talk about that 1 week that I win all season long, and I will lead you to believe it was the only game in the season that mattered. And you'll know I'm full of hot air when I do it, but we'll have fun. What's wrong with fun?
And I will say the best part.
When did fun become against the law?
Yeah, the best part of fantasy football is the collegiality. I'm in a couple of leagues. I'm only in 2 leagues, but I have so much fun talking to the people that are in that league that we agree on, that as the thing that we're doing. But it is a great way to meet new people and discover overlap in likes and opinions and just talk about things that are in orbit of professional sports, while also getting at that competitive aspect of wanting to be number one. So anyway, you know how to reach us now, pattispodcast@gmail.com. You should send us an email to pattispodcast@gmail.com anyway, just so we can start beginning to get our email list together. Just another way for us to sort of independently network and maintain connection with you outside of just those various areas that you find us day to day. As a reminder, we're live every day, 8 a.m. Eastern Time on X. We do live broadcasts there. Please follow us at LawPod Daily. We're also on Rumble Video. Thank you to everyone on Rumble today, and also on YouTube Live. So thank you to everyone watching live on YouTube. Don McNeil, looks like we got. Look, let's do it. Just let's have a little bit of fun, even if we have to create 2 leagues and run them sort of in parallel. I think this will be a lot of fun for us, and it's the first year, so we'll learn some stuff. Mari says, hit the like button. Do it, damn it! Hit the like button. And if you don't catch us here and you find us on Apple Podcasts or Spotify or Google Play, Overcast, whatever it is, give us 5 stars over there and leave a nice comment. Just leave like a little smiley face or something. Anyway,
and here's a thought to leave you with for the weekend: is Donald Trump losing it? I mean, there's inconsistency between how he's managing his quote unquote presidential campaign and how he's letting his legal affairs be managed. Somebody's got to get those 2 halves of his brain under control, because as far as I'm concerned, he's beginning to spiral down the drain. And I know you Trump lovers are going to say, oh, it's not loyal to the Donald. I'm not loyal to anybody, but to the principles that I think should inspire the republic. And I think Donald Trump is beginning to lose focus of them, beginning to lose focus of what he's doing and becoming an ineffective candidate. We'll talk about that next week.
Yes, we will. That was something that we had on the schedule for today, but I think we dove in deep, and the participation from the chat today is awesome. So thank you all again. We'll talk about the LA Times article about Section 3 of the 14th Amendment, something that Norm and I covered earlier this week that's been picked up in the LA Times now. Go over there. I call her Fulton County Fanny. She wants to have a trial in March of 24.
Of course she does.
In the Georgia case.
She's got her hairdresser lined up.
Right. And then
they get to the fat farm, slim down a little bit. They don't use wide angle cameras in the courtroom.
And what Norm was referring to just a couple of seconds ago is just the sheer weight of the indictments, the cumulative weight, and the inability or ability of Trump to steer back into something that looks like a cohesive candidacy for president. And I say that knowing and acknowledging the significant headwinds, unprecedented headwinds that he's facing. But I think that, Norm, I agree to the extent, the example is that he's not going to reveal the Georgia election interference information that he has on social media as previously advertised. Your opinion is that that is some expression of an overly conservative approach. His attorneys have told him, let's put it in legal briefs. So anyway, we'll talk more about that next week. Thank you all for being here. Make sure you're subscribed. You've hit the like button on these videos. And Norm, I'll see you next week.
Yeah, we'll talk later in the day. I know we got some business to talk about. So.
Indeed we do. All right. Bye.